In the previous session, we had discussed about guarantee and we spoke about three parties who are a part of the contract of guarantee. One is principal debtor, the person in respect of whose default the guarantee is given, the creditor, the person to whom the guarantee is given, and the surety, who's the person who gives the guarantee. In this session today, we will discuss about surety in detail. Now, let's start reviewing the rights of the surety. The rights of a surety can be categorized against the principal debtor and his rights against the creditor and his rights against the co-sureties, if at all there are any who exist. Starting with his rights against the principal debtor, there are two rights he has: right to subrogation under section 145 and right to indemnity, which is also under section 145. Right to subrogation. After paying the guaranteed debt, the surety steps into the shoes of the creditor and acquires all the rights which the latter had against the principal debtor. That is, he gets the subrogated to all the rights and remedies available to the creditor. Right to indemnity. The surety is entitled to be indemnified by the principal debtor for all the payments rightfully made by him. So these are the two which are his rights against the principal debtor. Let's look at his rights against the creditor. Right to securities. Under section 141, the surety can, after paying the guaranteed debt, compel the creditor to assign to him all the securities taken by the creditor either before or at the time of the contract of guarantee. Whether the surety was aware of them or not, it doesn't make a difference. Right to claim set off. The surety, on being called upon to pay claim any set off to which the principal debtor is entitled from the creditor. The right against co-sureties, which is right to claim the contribution. Surety can ask his co-sureties to contribute the amount when principal debtor comes across a default. If they have given guarantee for equal amounts, they have to contribute equally. In case where the guarantee is for equal amounts, the mode of contribution differs from England law to Indian law. So there are a bit of differences in terms of the way the co-surety contribution is calculated in England law versus as it is calculated in Indian law. In Indian law, it is calculated based on exactly the amount or the percentage of amount the surety had given. Now let's look at the surety, whether he can get discharged from his liabilities or not. Section 128 of the surety is coextensive with that of the principal debtor, unless it is otherwise provided by the contract. It means that on a default having been made by the principal debtor, the creditor can recover from the surety all what he could have recovered from the principal debtor. So that's the basic definition which is given under section 128. There are specific scenarios or situations under which the surety can be discharged from his liability. And again, there are three categorizations which are given for discharge of surety liability. One is by revocation, the other is by conduct of the creditor, or third is by invalidation of the contract. Starting with by revocation, the revocation then by can be done by notice under section 130. A continuing guarantee may at any time be revoked by the surety as to future transactions by notice to the creditor. The section permits revocation when it is a continuing guarantee and it is as regards to the future transactions only, not to the past transactions. The second is by death of surety. Under revocation, the death of the surety operates in the absence of any contract to the contrary as a revocation of a continuing guarantee as far as at it regards to the future transactions. Again, it's not to do with the previous transactions that have already happened. Third is by innovation, which is under Section 62, when a fresh contract is entered into either between the same parties or between other parties, the consideration being the mutual discharge of the old contract. The second head is discharge of surety liability by conduct of the creditor. The first is by variance in terms of the contract under Section 133. When the surety has undertaken liability on certain terms, it is expected that they will remain unchanged during the whole period of guarantee. If there is any variance in the terms of the contract between the principal debtor and the creditor, the surety gets discharged by default. By release or discharge of the principal debtor, as per Section 134, the surety is discharged by any contract between the creditor and the principal debtor by which the principal debtor is released, or by any act or omission of the creditor, the legal consequences of which is the discharge of the principal debtor. By arrangement between principal debtor and the creditor, as per the Section 135, a contract between the creditor and the principal debtor by which the creditor makes a composition with or promises to give time to or not to sue the principal debtor discharges the surety unless the surety assents to such contracts. By creditor's act or omission impairing surety's eventual remedy, if the creditor does not act uh, does not does any act which is inconsistent with the right of the surety or omits to do an act which his duty to the surety requires him to do, and the eventual remedy of the surety himself against the principal debtor is thereby imparted, the surety is discharged in that situation as well. By loss of the security by the creditor under Section 141, the surety is entitled to all the securities which the creditor has against the principal debtor at the time when the contract of suretyship is entered into. If the creditor loses or without the consent of the surety parts with such security, the surety is discharged with the extent to the value of the security. The third categorization under which discharge of surety liability is by invalidation of contract. First one being guarantee obtained by misrepresentation, which is under Section 142. Any guarantee from the surety which has been obtained by means of misrepresentation made by the creditor or with his knowledge and assent concerning a material part of the transaction is invalid. Guarantee obtained by concealment under Section 143. Any guarantee which the creditor has obtained by means of keeping silence as to material circumstances is invalid. And lastly, failure of co-surety to join surety under Section 144. Guarantee on contract that creditor shall not act on it until co-surety joins. When a person gives a guarantee upon a contract that the creditor shall not act upon it until another person has joined in it as a co-surety, the guarantee is not valid if that person does not join. Now, in this session, we covered the rights of the surety against the principal debtor, against the creditor, and against the co-sureties. We looked at the definition under Section 128, um, uh, defining the liability of the surety, and we also looked at the discharge of the surety's liabilities and when they can get when the surety can get discharged from his liability, either by revocation or by conduct of creditor or by invalidation of contract. You can download this presentation from www.jurisknowledge.com. Thank you.